lawsuit. And one of the procedures you will be involved in is a deposition. Quite simply, a deposition is a question and answer session between you and the opposing attorney. In most circumstances, the deposition will be taken in your attorney's law office, perhaps in the conference room or the library of the attorney's office. Sometimes the deposition is conducted in a neutral site. Even though the deposition might appear to be somewhat informal, it is anything but that. A good opposition attorney may well attempt to be somewhat disarming, warm and friendly to you. It is to the opposing attorney's advantage to make you feel comfortable, because that may well catch you off guard. The thing that sets a deposition apart from a regular conversation or a friendly question and answer session is that this is for the record, the court record.
All rise. 167th District Court is now in session. The Honorable Bob Jones presiding.
From having watched, no doubt, many television shows and movies, you are familiar with the formality of the courtroom. There is a judge, there are the opposing attorneys, the jury panel, and, of course, the court reporter with the court reporting machine. This is a very sobering experience, one that not many citizens witness firsthand. The point I'm trying to make here is that the deposition you are about to give is just as sober and formal as if the testimony were given in any courtroom. First, let's examine the participants in your deposition. There is, of course, your attorney who is there to protect you and make sure that opposing counsel doesn't get out of bounds with any of his or her questions or conduct. Next is the opposing attorney who will direct the line of questioning. And finally, the person who takes all informality out of this meeting, the court reporter. It is the job of the court reporter to transcribe everything uttered in this meeting that will later be introduced in court should your case actually wind up in court. It will be typed in a booklet form and look like this.
Your deposition.
It is important to note here that in many instances, your case may not wind up in court. Often, cases are settled out of court on the strength of the deposition given prior to court. However, in just about all cases, the party's deposition is taken. This is why it is of paramount importance that you be properly prepared for your deposition. One should always be properly groomed for the occasion. Clothes should be conservative in nature, hair neat, and shoes shined. This applies to male and female. Your appearance should reflect that you take your case seriously. Always remember, the court reporter is silent. In fact, you may well forget the reporter is even present.
Good morning.
Hi.
How are you?
Welcome. I'm fine, and you?
Well, thank you. I'm doing very well. I have to admit I am a little late, but I had the opportunity of parking next to that beautiful new Sable you have down.
Often during the course of the deposition, the two attorneys will exchange barbs and engage in friendly banter. This is disarming. Be aware, because no matter how casual the session appears, the court reporter is recording everything. Now, let's talk about some rules for giving your deposition. You have a natural advantage because juries associate with you, the witness, because they have the popular misconception that all lawyers try to take advantage of witnesses. So much of what we say is to help you keep this natural advantage.
How will your production company profit by impeding my client's career?
Your client's career is not being impeded. It's my production company, if anything, that's being impeded here.
The most important rule I can provide to you is don't get angry. Don't argue with the opposing attorney. Keep your cool. The best way to blow your case is to let the opposing lawyer get you mad. If that happens, juries stop sympathizing with you. Juries and judges expect witnesses to remain calm during interrogation because they believe truthful people are calm people. You will never win an argument if you get emotional and the other side gets to ask all the questions and all you get to do is answer.
The contract you signed with my client, is that the standard STAR contract?
Yes.
Do you have the financial backing required for both the out-of-town and the New York runs?
Yes, I do.
In this regard, always treat the opposing attorney with respect. It's like the old military saying, you salute the uniform, not the man. Accordingly, call the opposing attorney sir or madam, and treat them with the same respect with which you treat your own attorney. There are, of course, some very elementary pitfalls to avoid during your deposition, and we will give you some examples of how to give a good deposition and what can happen if you stub your toe.
How many trucks did you have in your laundry business when it started 10 years ago? 2. And how many does it have today?
4.
How many employees?
A deposition is not a conversation between you and the opposing counsel. In a normal conversation, you frequently know what the other party is talking about, even if the words do not make sense. You know it by facial expressions, by the context of the question, or by simple good guessing. That is not what a deposition is about.
And this rapid expansion in your
This may be hard to remember. You were there to answer only the questions of the other lawyer. You were there to answer them truthfully, but nothing more. You are not obligated to guess what is meant by the questions or to tell facts that you think the attorney meant to ask. Pretend your opposing lawyer is a computer. You have to wait for the questions to be typed before you can answer, and then you answer just what the question is asked. Don't volunteer.
And on what date did you sign the contract with
It was
Center?
February 18th. I think you have that information.
I see. Well, thank you, sir. And when did you sign the contract with Center Stage Productions?
Oh, that was December 1st.
And have you gone into overlapping contracts before?
Never interrupt the question, even if you surmise the end of the question. Always wait until the question is completed. Then pause, take a deep breath, and then respond.
And on what date did you sign the contract with Center Stage Productions?
It was December 1st.
December 1st. Thank you.
This will accomplish 3 things. It will allow you to think, get your composure, and give you a level response. Remember, the court reporter is taking everything down verbatim. Again, by verbatim, I mean each and every word. So if you should stumble and try to correct yourself, it will be reflected in the transcript. What we have talked about so far have been some of the mental preparations for your deposition. There are, however, some very basic preparations you should make. Let us move into a deposition and explore some of those things that we have talked about thus far. In this case, Mrs. Jones was driving her car toward an intersection. Halfway through the intersection, her car is hit on the left rear by the other car. The other lawyer is taking Mrs. Jones's deposition and is attempting to show that Mrs. Jones was at fault because she failed to be properly watching as she entered the intersection.
As you approached the intersection, was there anything blocking your view?
I had just pulled out the lighter for my cigarette, was tuning the radio, and I saw the car.
Oh, you were smoking?
Yeah, I smoke a couple of packs a day, but I'm trying to quit. In fact, I was on my way to the doctor's office.
Oh, you were sick?
I didn't say I was sick.
What was the name?
I'm completely over the flu. And I
What was the
haven't had
doctor's
any
name?
of the medication for 2 days. I wasn't drowsy on the day of the wreck.
Several bad things have just happened, and she may well have blown her case. She got mad, and she argued. Now the opposing attorney knows he can rattle her in front of the jury. She interrupted the question and guessed what he was asking. And most importantly, she volunteered information.
As you approached the intersection, was there anything that blocked your view?
What did the question ask? Was there anything that blocked your view of the intersection?
I had just pulled out the lighter for my cigarette, was tuning the radio, and saw the car.
Oh, you were smoking?
Yeah, I smoke a couple of packs a day.
It did not ask about smoking. It did not ask about radio.
In fact, I was on my way to the doctor's office.
Oh, you were sick?
I didn't say I was sick.
And what was the name?
I'm completely over the flu.
It did not ask about doctors. It did not ask about illnesses.
And I hadn't had any of the medication for 2 days, and I wasn't drowsy on the day of the wreck.
It did not ask about medication or the effect of medication, all of which was volunteered. Let's see how it should have been handled.
As you approached the intersection, was there anything that blocked your view?
No, sir, there wasn't.
Did you see the car coming before you entered the intersection?
Yes, sir, I did.
Well, why did you go on through the intersection?
She had a stop sign, and she was slowing down, so I assumed she'd stop.
Oh. Were you drinking or under the influence of any medication?
No, sir, I wasn't.
You notice that she answered the question honestly and thoughtfully. She did not interrupt.
As you approached the intersection, was there anything that blocked your view?
No, sir, there wasn't.
Did you see the car coming before you entered the intersection?
Yes, sir, I did.
She did not anticipate the end of the question. She did not get angry.
Were you drinking or had you been on any medication that day?
No, sir, I wasn't.
She answered only the question asked and did not volunteer information that was not asked for.
And on what date did you sign the contract with Center Stage Productions?
That was December 1st.
December 1st? Thank you.
As you can tell, it is extremely important that you listen very carefully to the questions that are presented to you by the other lawyer. Again, there are several rules of thumb that you should keep in mind as your deposition is being taken. First of all, you may not know the answer to a question. There's nothing wrong with not knowing the answer to a question.
What is the average production time for location filming of this nature?
I don't know.
Will your involvement require you to remain on location throughout the duration of the film?
I don't know that either. Simply tell the lawyer that you don't know. Some witnesses think it's a sign of ignorance if they do not know the answer to a question. That's hardly the case. You can only do harm to your case if you answer a question that you do not know. Likewise, your opposition lawyer will undoubtedly ask you a question that does not make any sense. There is nothing wrong with not understanding a question.
Did you understand the impact of the obligation clause in the Center Stage contract prior to negotiations with Paramount, recognizing this would place you in an overlapping contractual agreement?
I'm sorry, would you rephrase that question? Simply say, would you rephrase that question? There are three types of questions about which you need to be especially careful. The first is a compound question.
When you cast my client in your show, were you aware that he's rising in popularity, that he gets a lot of offers, and that your production had no opening date?
Yes. Yes.
One in which your opposing lawyer puts two or more questions together, and where most of the question can be answered with the simple answer, but part of the question is wrong.
Yes. Yes.
Your instinct is to be agreeable, even though part of the answer is wrong. Unfortunately, if you answer the question with a simple yes or no, you will be bound not only to the part that is right, but also to the part that is wrong. Frankly, the lawyer may be doing this deliberately to entrap you. The second situation occurs when a lawyer asks you a question that assumes facts that are not true.
When you cast my client in your show, were you aware that he is rising in popularity, that he gets a lot of offers, and that your production had no definite opening date?
Well, there are actually a few questions there. To the first two questions, the answer is yes, and to the last one, the answer is no.
The have you stopped beating your wife question, which cannot be answered yes or no because it assumes you were beating your wife in the first place. In these instances, you must pause and make sure you correct the falsehood before answering. The third situation is where, after all the questions have been completed, the opposing lawyer tries to get you to agree to a summary of your testimony.
So I signed the contract with Center Stage Productions on December 1st. Then, on February 18th, I signed the contract with Paramount.
Ah, so you were aware that you entered into two contractual agreements that were mutually exclusive.
No, that's not what I'm saying. I signed the contract December 1st with Center Stage. Then we began...
Never let the other lawyer put words into your mouth. Let's demonstrate what we're talking about. In this case, Mr. Thompson is being sued for divorce by his wife, Sue. Mr. Thompson owns a small dry cleaning service which he has operated for the past 10 years. Mrs. Thompson's lawyer is attempting to establish that the business is doing extremely well and will continue to enjoy an explosive growth.
How many trucks did you have in your laundry business when it started 10 years ago?
2,
And how many does it have today?
4,
How many employees did you have originally?
5,
And how many do you have today?
10.
And this rapid expansion in your company has occurred because of your education, the new technology you've brought in, and the heavy growth of population in your area.
I guess so.
Well, you certainly have plans to open several stores in the next 5 to 10 years.
I guess so.
So, in summary, Mr. Thompson, over the last 10 years, your company has expanded dramatically, having more than doubled its fleet of trucks and employees, and your company will more than double itself in locations and employees over the next 5 years?
I suppose so.
As you can tell, Mr. Thompson has been trapped into testifying about things that are simply not true.
How many do you have today?
10.
And this rapid expansion in your company occurred because of your education, the new technology you've brought in, and the heavy growth of population in your area.
I guess so.
The lawyer has put words into his mouth by asking a compound question.
Well, you do intend to double your locations and employees in the next 5 years.
I guess so.
In addition, the lawyer asked a question which assumes facts that weren't true, namely that the business had rapidly expanded.
So in summary, Mr. Thompson, over the last 10 years, your company has expanded dramatically, more than doubling its fleet of trucks and employees, and your company will more than double itself in locations and employees over the next 5 years.
I suppose so.
And finally, the wrongful summarization of prior testimony. How do you avoid these traps? Let's watch.
How many trucks did you have in your laundry business when it started 10 years ago?
2,
And how many does it have today?
4,
How many employees did you have originally?
5,
And how many do you have today?
10.
And this rapid expansion in your company occurred because of your education, the new technology you've brought in, and the heavy growth in population in your area.
No, wait a second. I never said that we had a rapid expansion in my company. Quite the contrary. The activities we had done have merely allowed us to net the same over the years because of new competition.
Oh, I see. Well, do you intend to double your locations and employees in the next 5 years?
No.
Do you deny that's what you told your wife?
I told her certain expansion was necessary in the future.
So in summary, Mr. Thompson, over the last 10 years, your company has expanded dramatically, more than doubling its fleet of trucks and employees, and your company will more than double itself in locations and employees over the next 5 years.
No. The proper summary is that my company's expansion in the past was accomplished merely to meet the demands of new competitors in their technology. The activity did not increase the profitability of the business. In fact, the percentage of profit is dramatically down. The future is hopeful, but it's too early to speculate on.
I see.
So remember, don't let the opposition lawyer put words in your mouth.
So in summary, Mr. Thompson, over the last 10 years, you have more than doubled your business in trucks and employees, and over the next 5 years, you will more than double your business in locations and employees.
No.
The proper summary is that my company's expansion in the past was accomplished merely to meet the demands of new competitors in their technology.
Don't let the lawyer get away with making you answer several questions in one.
And this rapid expansion in your company occurred because of your education, the new technology you've brought in, and the heavy growth in population in your area.
No, wait a second. I never said that we had a rapid expansion in my company. Quite the contrary.
Simply say, please break down your question. There are some other concepts that we now need to talk about. In answering questions in a deposition, don't characterize your testimony.
Were you aware that my client is in great demand?
No.
Did it occur to you that he would have other job offers?
No, it didn't. Honestly, it didn't.
By that I mean that phrases like honestly, I'm doing the best I can, and in all candor are not appropriate. If you start out an answer with the word honestly, is the court and jury to believe the rest of your testimony was not honest? Of course not. These are simply figures of speech you use in everyday life, but are not appropriate for a deposition.
Have you ever had to recast a part in a show?
No, never.
Likewise, try to avoid words like never and always. If the lawyer asks you if you've ever done a certain act and you say never, the lawyer will be able to attack your credibility if one exception is found.
Have you ever had to recast a part in a show?
No, not that I can remember.
So it's best to say, not that I can remember, or to the best of my knowledge, no. There will probably be one type of question used in your deposition that you need to know about in advance.
Can you fulfill both contracts simultaneously? Can the filming be postponed or moved up, perhaps? And were you aware that the filming of the movie in Greece would present a travel problem?
You're asking me several questions here. In response to the first question, we haven't set any production dates for the film, so I don't know.
At some point, the lawyer will ask you a question that requires you to tell him everything you know about a certain subject, or to tell everything you remember about a conversation or an event. What's the lawyer trying to do? First of all, the lawyer is trying to get your full story. But equally important, the lawyer is trying to freeze your testimony so that you will look like you're lying if you remember additional facts later. The lawyer is trying to put a box around your testimony. Let's give you an example of what we're talking about. In this case, Mrs. Smith was injured, and the lawyer is attempting to freeze her story about her injuries.
Now, Mrs. Smith, please tell us everything that hurt after the accident.
My back hurt, and still hurts to this day.
What part of your back?
The middle and lower level.
What type of pain?
A sharp pain, like a knife.
Anything else bother you?
I scratched up my left leg.
Anything else?
Yes, there were some bruises on my feet.
Anything else?
No. That's it.
You're sure? Huh?
I'm doing the best I can.
Well?
No, that's it.
In reality, within 24 hours of the accident, Mrs. Smith started having severe headaches that lasted for several months. She simply forgot about them in the anxiety that most people have during a deposition. Let's see what happens to her in court.
Mrs. Smith, you just testified that you had headaches after the accident?
Yes, sir.
And do you remember that I took your oral deposition 8 months ago?
Yes, sir.
And do you remember that I asked you to tell us everything that bothered you?
I think so.
Did you tell us about a headache at that time?
I don't remember.
Mrs. Smith, I ask you to look at page 40, line 14 of your own deposition.
No, I don't see it.
Were you sworn to tell the truth at that time?
Yes, sir.
Did you tell the truth?
Well, yes.
Wouldn't you agree with me that your recollection of the incident was better 8 months ago than it is today?
I guess so.
Mrs. Smith, which testimony would you like this jury to believe, 8 months ago or today?
The witness had simply forgotten about her headaches because the most painful part of her injury was her back. Now the jury may not believe anything she says. Here's a way to truthfully handle one of these tell me everything type questions.
Now, Mrs. Smith, will you tell us everything that hurt after your accident?
My back hurt.
What part of your back?
The middle and lower level.
What type of pain?
A sharp pain, like a knife.
Anything else bother you?
Yes. I scratched up my left leg, and there were some bruises on my feet.
Anything else?
Mr. Johnson, I'm sure that there were other things that bothered me. It's very difficult to sit here now and recall everything that happened 11 months ago. If you have some documents or maybe a medical record that might refresh my memory, I'll be happy to try and recall the other problems.
But you think that's all?
Like I said, I'm sure there were other things that would probably come back to me if I weren't so nervous.
Anything else?
As you see, Mrs. Smith avoided closing the box. And when she honestly remembered additional facts, she did not give a false impression of lying. Let's review some of the rules we've talked about today. Tell the truth. Don't volunteer. Don't argue or get mad. Treat the other lawyer with respect. Listen carefully to the question, pause, and then answer only the question asked. Look out for trick questions. If it contains more than one question, make the lawyer break it down. If the question contains false statements, clarify those false statements. Don't let the other lawyer put words in your mouth. And finally, don't let them close the box on your testimony.